So it's an absolute pleasure to be here in Dresden. It's my first visit, but now that I have the hat, I think I can come back and fit in quite well with the crowd. Thank you to Lars for inviting me and giving me this opportunity to give this talk. Some of you I've known through correspondence, and some of you I'm meeting for the first time. The talks this morning have been spectacular and really informative to me, and truly I think as Lars mentioned at the outset, truly offer the diversity in the most important sense, which is really people with different perspectives and know different things coming together to share information. And so it's been a great morning, and I'm looking forward to the rest of the day. This is a picture of my home university. Here's our American football stadium. It holds 50,000 people, and we use it 6 days a year. Those 6 days are very exciting, though, I can guarantee you. And our team is called the Colorado Buffaloes, and we have a live buffalo, a huge beast that comes out right here and runs around the field and then back over here to start each game. And so win or lose, when you get to see, the buffalo has a name, Ralphie. So win or lose, when you get to see Ralphie run, it's always a good time. I'm here to talk about a subject that is near and dear to all of our hearts. It sometimes goes by different names, but I decided to give it the longest name I could come up with for the title of Investment Crowdfunding. As Lars said, this is a book that I published. It's my first book. It might be my last, so enjoy it while you can. Today, I'm going to give you, here's a road map. This is what we say in America, the road map of my discussion today. I'm going to, some of this will be intimately familiar to you, but really most of what we've heard today is really from finance, economics, quantitative perspective, and so I wanted to offer really the legal perspective. And so I'm going to define what is investment crowdfunding. I'm going to explain what I see, and it's not just me, what I see as the goals, the purpose, why we're doing this. I'll give you a bit of a report on the US, how things are going there, or to what extent are we achieving these goals. And I'll also talk a fair bit about comparative law, including the ECSPR, and the law in other countries. I'm going to spend a fair bit of time on private ordering, by which I mean methods of organization, at least of the crowdfunding market, that are not driven specifically by law, but by the economic incentives of the market participants. And then finally, if you stay awake that long, I'll give you a promo code so you can buy the book at a discount. Great Christmas present for your niece or nephew. So here we go. The definition. Well, in the beginning, there was Kickstarter, and it was good. But the fundamental rule of Kickstarter and what I call more generally reward crowdfunding was you can offer people an app or a record album, or your name in the credits, or some other tangible or intangible reward for crowdfunding your project, but it would violate in the United States, the Securities Act of 1933, which is pretty old, but still quite in force. And the basic rule of the Securities Act is that before you offer securities, meaning any type of financial investment, stocks, bonds, preferred stock, etc., any sort of investment opportunity, you must register the securities with, in the United States, and this is true elsewhere, in the United States, you must register your securities with the SEC, the Securities and Exchange Commission, which was created in a similar and related law in the United States in 1934, which is quite some time ago, but is still going strong. And what it means to register your securities, and I think everyone is basically familiar with this, is to file with the SEC or your national competent authority. You must file a huge amount of information, mandatory disclosures about the company, its finances, the risks, who's running it, how the business is going. And that's fine, and it's useful. We usually call it in the US an IPO, an initial public offering. It's useful to provide investors with information and disclosure about the company so they can make an educated decision about whether to invest, but it's also very expensive. In the United States, it costs somewhere in the range of $3, $4, $5 million to conduct an IPO, to gather all the information, hire all the lawyers to write it up, engage accountants and others. And if you are Tesla and you're raising $860 million, to spend $4 million on the process is maybe a reasonable thing. But if you're a startup company seeking to raise $500,000, $2 million, we may not be mathematical experts, but we can appreciate that spending $4 million in the process of raising $2 million is obviously impossible. Thus, for decades and decades, startup companies have, out of necessity, had to raise money through by selling securities without registering them, without going through that whole process. And the Securities Act of 1933 and similar law elsewhere includes a number of exemptions, situations where you may sell securities without having to register them. And so the two most important ones, at least for many decades, have been, first of all, the private offering exemption. So if you offer securities only to people you personally know, your friends and family, your neighbors, your colleagues, then you are exempt from registering the securities. And so that's one major way that startups have gotten off the ground. The second is the accredited investor exemption, and other countries use different terms, sophisticated or wholesale, but the point is, at least in the US, an accredited investor is a professional investor, like a bank or an insurance company or a venture capital firm, or any individual who has at least $1 million to invest. And the idea, and these are the angels that Bernadetta was talking about earlier, the idea here is not really that people that have $1 million to invest are smart or sophisticated. I mean, maybe you just won the lottery the day before. You don't suddenly become smart. But the point is, the reason why we have this exemption is that these investors, by definition, can afford to lose. That they can invest, and if the investment doesn't work out, they're not going to go hungry, their children aren't, will still have shoes. So these two exemptions have shaped, for decades and decades, the market, the capital market for startup finance. On the one hand, we have the private placement exemption, and so entrepreneurs raise money from their family and friends privately. And on the other hand, we have the accredited investor exemption, so entrepreneurs raise money from angels and venture capitalists. And this is how it's gone for many, many decades. But it was thought maybe we can use in Kickstarter got started around 2008. This was reward crowdfunding and similar platforms in other countries. it was thought maybe we could use crowdfunding as a way to fund startup companies. And so, look, maybe unlike the laws of nature, the Securities Act can be amended at any time. And so, in the United States, Congress enacted what we call the Jobs Act, JOBS. It stands for Jumpstart Our Business Startups Act, the Jobs Act in 2012, a huge bipartisan majority in Congress, signed into law by President Obama. And the Jobs Act, at least the most important part for our purposes, created an additional exemption from registration for investment crowdfunding, as long as you followed the special rules that were laid out in the Jobs Act and the subsequent regulations that the SEC put out called Regulation Crowdfunding. And similar laws were enacted across the world. In New Zealand, there was a special statute. Australia, Canada, the countries across Europe, the EU spent, I don't know, maybe it was like 8 years coming up with the ECSPR rules. And so, through investment crowdfunding, so this is how I define investment crowdfunding. It is the public offering, so not just privately, of unregistered securities through an independent online platform modeled on Kickstarter, and we've talked about platforms throughout the day. And so why did the U.S. pass this law? Why did other countries follow suit? The goals, the policy goals were, I submit, there were 3. And some countries, in some jurisdictions, some of the goals were more important than others, but these are the 3 main goals of investment crowdfunding. First, a new source of capital for startup companies. Startup companies, entrepreneurship is widely seen, and I think rightly so, as socially beneficial. They create new products, they create jobs. Remember the thing was called the Jobs Act. And so this is just a new way for companies just getting off the ground to find capital. But in the U.S. at least, and I think, let me say this, in some countries, like let's say New Zealand or Australia, they have, at least in their view, and I think there's truth to it, they have a lot of good startup companies, but insufficient venture capital and angel funding. So they just plumb needed additional capital going to their startup companies. In the US and Israel and certain other countries, there's a lot of venture capital funding, but there were additional reasons why investment crowdfunding was adopted. And so the first is inclusive entrepreneurship. And you see both of these are about inclusivity. For entrepreneurs, remember what I said. If you have a startup company, where are you going to get capital? From friends and family, or from angels and venture capitalists? Well, what if you don't have wealthy friends and family who can invest? And what if you live, I don't know if you know the U.S. well enough, but what if you live in North Dakota or somewhere really far away from Silicon Valley or other hot spots for venture capital? What if you don't have any connections to any of these traditional sources? There are entrepreneurs out there who come from modest backgrounds and who are out of the loop for one reason or another. Racial minorities in the U.S., women-founded companies have had a particular lack of success in getting their startup companies funded through angel investors and venture capitalists. So, through investment crowdfunding, it was thought, hey, we could give these entrepreneurs a way to go online, and kind of pitch their idea to the crowd of people across the country and get funded in that way. It would be a more inclusive mode of entrepreneurship. And on the other side, what about the investors? Remember, I told you the two key exemptions, the two key ways to fund startups was private placements and accredited investors. But what if you're just like a regular person and you don't happen to know Mark Zuckerberg and you are not wealthy enough to qualify as an accredited investor? It was thought that wouldn't it be useful and valuable to give these investors, the American people, a chance, or people across the world really, a chance to participate in this startup capital market. And as one of the congressmen, he's now the governor in Colorado, as one of our congressmen at the time, as they were debating this, he said, through investment crowdfunding, ordinary people are going to finally have the chance to lose their money, just like the wealthy always have. But he was sort of joking, and he was actually a proponent of the bill and voted in favor of it. But it's certainly true that startup investing is risky, and so the U.S. and other jurisdictions did not just sort of say, go for it. They put in legal regimes to protect investors, to police the market, to deter fraud, and many other things. And I'm going to come in a few moments to tell you a little more specifically about the law in the U.S. and elsewhere. But before I do, let me give you a bit of a report on how it's going in the United States. Remember the three goals. Let's keep here they are: new source of capital and inclusive entrepreneurship and investing. So the Jobs Act was passed in 2012. The SEC took 2013, 2014, and 2015 to write the regulations, regulation crowdfunding, and then finally it was put in place in 2016. And so that's why my chart starts at this date. And what I'm showing here is the total market in the US, how much was raised per year in millions of dollars, and in the first year, a few tens of millions of dollars, and it's been growing. To this point, we're at about in the range of $500 million per year. I have to confess, this does not go like this in the future years, where I'm not showing the data. It kind of is flat. But to be fair, venture capital funding and angel funding at this point kind of went down like this. So to go flat was kind of a win for investment crowdfunding. And one thing that the SEC had a variety of other things to do in these years, and that's why it took them so long, but also the SEC, going back to 1934, has taken it as their touchstone. The fundamental principle of securities law is mandatory disclosure. That you must give people information, and we're going to tell you, we're the SEC, we're going to tell you what pieces of information you must give investors before they're allowed to invest. And the fundamental rule, the key move of the Jobs Act was to exempt crowdfunded offerings from mandatory disclosure. So the SEC, I don't know if they'll say it out loud, but they were a little bit, it sort of is hostile to their religion of mandatory disclosure. But so investment crowdfunding has created a new source of capital for startup companies. I do also have to say that this represents somewhere around 1% of venture capital funding in the US. So it is quite small on a relative basis, but hey, back here it was 1/10 of 1%. So we'll see what the future holds. The number of offerings per year, remember we're trying to give entrepreneurs a chance to get their companies funded, And how many entrepreneurs were interested? Well, in the first year, not even 200, but then it doubled, and pretty much doubled again, and doubled again. And again, this too has kind of flattened out to about 1,500 offerings per year, which is a lot of companies, but it's also a big country. The number of investors or people interested in this, and in terms of inclusive investing, well, like I said, in the early years, this was really quite small. We only hit 100,000 investors, and I don't know if you know, but America's got like 300 million people. It hit about 100,000 investors. It doubled again, not quite doubled again, and this is also kind of flattened out and has stayed pretty steady at about 500,000 investors. One more chart I'll show you. I don't have too many more charts, but there are a couple. Remember, we're looking for, among other things, inclusive entrepreneurship. And different sources have different figures, but in broad strokes, this is about right. That female-founded companies, women-founded companies, receive 10% or less of the capital that venture capitalists put forth each year. But in investment crowdfunding, it's nearly half. It's about half. About half of the investment goes to female-founded firms, which is a huge improvement. And so this part of the goal really is actually coming to fruition. And look, I will say, what the specific numbers that I'm showing you here were from the year 2021, and the biggest, most successful crowdfunding campaigns of $1 million or more, but the numbers would be broadly similar in other ways too. For minority founders in the US, venture capital, they get about 20-25% of venture capital funding. In the US, again, it's about 40-something%. In the US, there's a particular focus on African American founders, and African American founders in venture capital receive about 1% of the funding, and the best figures that I've seen say that in investment crowdfunding, they're getting about 4%. Well, you might say, well, it should be 6. Well, okay, but 4 times as much is really a notable change and improvement. And anecdotally, I will tell you that at least in the US, the platforms that host investment crowdfunding offerings highlight African American founder, Latino, women founder, LGBT, etc. And you can search and organize them in that way. And investors are particularly enthusiastic for it. I'd say it's not a problem for these entrepreneurs. In fact, they sort of shout, "Hey, I'm an African American founder," and people are excited to invest. Okay, so moving from the US to comparative law, what I have here is a chart showing not all, but the key investment crowdfunding regulations in various countries. And so over here I have the US, Australia, Canada, EU, New Zealand, and the UK. And what I'm showing here is that every jurisdiction, yes, requires by law that the platforms that run this sort of business get a license to do so from the SEC or their national competent authority. Remember, mandatory disclosure was the costly thing of registration, and investment crowdfunding is exempt from it. But what Congress giveth, Congress can taketh away. And in the US, there is sort of a miniature set of mandatory disclosures that must be provided. And this is true in most jurisdictions. And this is kind of the big divide in the world that I see between jurisdictions. In the UK and New Zealand, there's no mandatory disclosure at all. They leave it entirely up to the platform and the company to decide what to disclose and in what format, and there are no specific rules on it. And so, largely for this reason, I split the world into most countries. I say they follow the standard model of investment crowdfunding, which uses this traditional tool of mandatory disclosure. But the UK and New Zealand, I call them the liberal jurisdictions. They follow the liberal model. They're more free and deregulated and do not mandate disclosure. Another key rule in every jurisdiction is that companies are limited, the issuers of the securities companies are limited in how much they can sell each year. In the US it's 5 million, in the EU it's 5 million, in Australia it's 5 million. New Zealand and the UK both were very early movers in this field. The UK had investment crowdfunding up and running by about 2012 or 2013, but not pursuant to a specific statute. Just their regulator, I don't remember if it was the FCA or I don't recall, the UK regulator just gave one-off licenses to a few different platforms, the biggest of which, and maybe you know these names, are Seedrs and Crowdcube. New Zealand saw what we did in the US and immediately followed suit in 2013 and had they did enact a special set of regulations that was up and running in 2014. And New Zealand and the UK, I would say, one of their major focus when they were enacting this was really to create a new source of capital. Like I've said, some jurisdictions have a lot of venture capital for startup companies and angel investors, and some have very few and really just want it to work and get more money to their startups. And so New Zealand and the UK tried to create very user-friendly, light-handed set of regulations, most notably without mandatory disclosure. But New Zealand has a very low limit, as you can see, just 2 million New Zealand dollars. That's like 1.5 million euros. And they haven't changed it yet, although I've been lobbying their parliament, see what I can do, help out the Kiwis. So all jurisdictions have a limit. If you want to go over this, you can do that, but you've got to go find accredited investors or have an IPO. This is for relatively small amounts. Most jurisdictions, but not liberal New Zealand, most jurisdictions also have an investor cap, and this is one of the most liberal parts of the EU regulation as far as I can tell. There's an investor cap. Each individual investor is limited in how much he or she can invest. And some countries, at least like the US, they do it on an annual basis. Most jurisdictions are on a per offer basis, like Australia, $10,000 per offer. And some jurisdictions like the EU and New Zealand have no limit, saying, hey, go for it. But the rationale for the issuer limit, one is that if we're going to have a minimal set of regulations, there's a concern that some of these companies really might blow up or fail or be fraudulent. The issuer limit just cabins any sort of social problem that could ever develop from a company turning out to be a fraud or failing. And I'll say in sharp contrast to various types of coins or NFTs and other things like that are unlimited. And when people get excited, they get excited. They will herd. And in the US, we've had multi-billion-dollar problems with various types of coins and such things. But so in the US and in all other jurisdictions, we accept that people are going to herd, But we say, okay, we're just going to cut it off to 5 million or whatever the number is. And the investor cap is, remember, the idea of the accredited investor exemption is that accredited investors with $1 million or more can afford to lose it. So we were trying to sort of make everybody into sort of a mini accredited investor. So you're only allowed to invest as much as you could afford to lose. Some jurisdictions limit, like Australia and New Zealand, you may only crowdfund equity. Just, that's it. They call it equity crowdfunding. Other jurisdictions like the US, and I'd say this is liberal in the US and the EU and the UK, you can sell any type of securities. Preferred stock, safes, whatever it is that you'd want to sell. And also various countries, most countries have a cooling off period where investors who reconsider and say, oh, I shouldn't have invested in that way, can cancel out their investment. I don't have it listed here, but in the U.S. and in some other jurisdictions, but not all, there's a rule that, and it's been referred to, was discussed earlier when we were talking about rebates. As we were talking about earlier, the rebates. The U.S. requires by law that investment crowdfunding be run under an all or nothing model, where the company announces a specific funding target, how long it has to get there, and only gets funded if we reach that level. Other jurisdictions, I think, mostly don't have this as a rule, but follow it as a practice. I will tell you, America is a special place, and we push everything to the absolute extreme. And if you give us an inch, we'll take a mile, a kilometer in your language. But the law says a company has to announce, and we've talked about success. They reached the target. The law says the company can decide what is its target and how long does it have to get there. Well, the platforms each kind of have an in-house rule of what the target is going to be for the companies on their platforms, and the target is designed so that everybody's a winner, everybody gets a medal. One of them, it's $10,000. Another one, it's $25,000. Meaning, a company can, once it has enough pledges to hit $25,000, the deal is going to go through. And like, lo and behold, the success rate is like everybody. And they can have as long as they want, so they generally give themselves a year or more. So it's typical in the US for a company to say, the minimum target funding is $10,000. We will accept up to the $5 million maximum, and we have 18 months to achieve this. And it's not working. That part's not working very well. But the reason the U.S. has mandatory disclosure and maybe not a thick rule book, but a thin rule book, and the EU as well. The EU rules are themselves thick, and I've seen the book that some of you contributed to of discussing the analysis of the rules is like 6 centimeters thick. I'm trying. I'm not metric system here. But the reason is that that we're going to let non-accredited investors invest in the startup companies of strangers over the internet without any of the usual securities rules that we have in place, like registration. People thought we're going to have a den of thieves. It's going to be full of fraud. It'll be huge problems. And so only a couple of jurisdictions, really led by these two, the UK and New Zealand, it took a lot of courage, I would say, for their government and their regulators to keep only a light hand on the industry and to kind of let it go. And so, well, let's see what happened. what I'm showing here is a comparison between the US, UK, see, I put them in red because they're the red codes. New Zealand is green because there's a lot of grass there. And Australia is purple because Excel just made the next one purple. But so what I'm showing here is a variety of years, 2016 to 21, the amount raised all in US dollars and per capita. Because it's just not fair to compare New Zealand to the US, and they have 5 million people there. We've got 5 million people in Colorado. So this, you can see this is the US, very, very small, kind of growing on the left side, doing okay. New Zealand has been strong throughout. This would be higher, New Zealand in green. But remember I told you they have this very low, about 1 or 1.5 million euro limit, so the amount of money that you can raise is just capped there. Australia is growing nicely since they got started, but the red of the UK really sticks out, and they have just outshone the rest of the world. And kind of to give away my whole thesis, I want you to buy the book, but to give away the whole thesis, my thesis is that because we have, everybody does, an issuer limit, because there's this low issuer limit, for this system to work, the regulatory compliance costs have to be kept to an absolute minimum. And the UK and New Zealand really took this to heart and have very, very few regulations. It's very liberal, it's very cheap to comply with, and the results are really quite good. We talked about angels earlier. In recent years, there are more crowdfunding deals each year than angel investments. I think the angels might have a higher amount of funding in pounds, but number of deals, there's more investment crowdfunding deals. And so this liberal model in the UK and New Zealand has really been successful on the market. And now you might say, well maybe not you, but like normal people would say, but whoa, there must be a ton of fraud in these jurisdictions where there's practically no rules. Are con artists taking advantage of the situation? Well, the answer is no. In the United States, where we have all these relatively heavy set of regulations, there's been about 4,000 or 5,000 companies funded in total, and there's been one claim of fraud. And I think it's a good claim. I think they fibbed. Fibbed means lied in a nice way. And so the US, we had one fraudulent offering. In the UK, where they have this very liberal set of rules, to my knowledge, and I would welcome an update, they've had one case of fraud. In New Zealand, where they have these very liberal rules, there has been one case of fraud. So, you can have a liberal set of rules that are inexpensive to comply with, and it's not going to be fraudulent. And, well, another question that you might be asking, or a normal person might ask is, well, how do the investors do? Does anybody make any money on these investments? When you're talking about the United States, I'd have to say I don't know. The whole industry is kind of too new. It takes time for these things to develop. I haven't seen data published on it, but the UK has a longer track record, and one of their two leading platforms, Cedars, recently put out a report saying that we've had about 1,000 companies that raised money on Cedars over the last 10 years. And how would you have done if you had invested in every single one of them? The answer is, if you invested 100, now look, I guess in the in the UK, it's sort of a funny thing. This is not a typo. The UK has an 8 million euro issuer limit because the rule dates back from before Brexit. but I'm going to talk in pounds anyway. If you had invested 100 pounds in every one of those 1,000 companies, you would have an annualized return of about 8%. This figure admittedly is, it's not a liquid market. This is based on the most recent funding rounds of those 1,000 companies. About 1/4 are out of business, about 3/4 are still going. And so if you invested 100 pounds in every one, you'd have about an 8% return annualized. But what if instead of investing 100 pounds in every single company, you invested in a market-weighted way? You bought 1% of every offering. Meaning, if there was a company that raised a lot of money, you would invest a lot. If they raised a small amount of money, you'd invest a small amount. Based on that, you'd have a return of about 13%. And this is, in this era, the FTSE in the UK, the public stock market, returned on a market-weighted basis about 6.5%. So it's not liquid like the FTSE, but this is twice the return of the FTSE. I think the best data and Cedars mentions this in their report, that venture capitalists in the UK during this time made something like 16 or 17%, so they did a little bit better. But I think this is really quite impressive, and it shows that there's a wisdom to the crowd. That the crowd does have wisdom. That the most popular offerings, the ones that got the most money, did better than on a fixed basis if you just invested in every one. So for those of you thinking about investing in this field, I would say follow the crowd. Notably, Cedars mentions that diversification was key. If you invested in the 1,000 companies, you would have made 8%. But most people didn't. Most people invested in 1 or 2 or 5. About maybe 60% of the investors on Cedars, in fact, only invested in one company. And I'm going to come back to this in a few minutes. This is an idea that I call brand ambassadors. The idea that the biggest fans of the company, people that use the app or buy the beer, that drink the beer, they go on to a platform to invest specifically in that company. The platforms have a huge private, economic, profit motive to act as reliable and strict gatekeepers that only allow legitimate and promising companies to list, because if they don't, if they just let anybody on and half of them are fraudulent or terrible companies, the investors won't come back. They'll go to some other platform next time they want to participate in this market. The platforms know this in advance and so act as responsible gatekeepers. And from my discussions, anecdotally at least, around the world, the platforms, the leading platforms at least, in various jurisdictions, only allow 2, 3, 4% of companies that want to participate actually onto the platform. And also, I did mention, so sort of a caveat to my basic thesis that you should just be liberal. What I would say is, when crafting regulations for investment crowdfunding, you should try to create ones that will support and work synergistically with these private ordering methods. So, for gatekeeping to work, there kind of needs to be competition among the platforms. If there's only one platform, that they might not care that the investors are going to go somewhere else because there's nowhere else to go. So, notably, in the UK, Cedars and Crowdcube sought to merge a few years ago. And the antitrust authorities there blocked the deal. They didn't say, see Professor Schwartz's book, but they could have. Is that you do need a pretty, it is important to maintain competition among the platforms for gatekeeping to work. Also, in the initial draft of regulation crowdfunding. In the US, when an agency like the SEC wants to put out regulations, it must first put out a proposed set of regulations and get comments, and then put out the final one. In the proposed regulations, the SEC had proposed that platforms must list everybody who asks. Radically inclusive. Remember, that was part of the idea. But in the final set of regulations, in response to comments from me and other people who said, look, SEC, the platforms need to be able to curate and screen and select who's going to go on their platform so they can establish a reputation as a reliable place. And so in the final regulations, the SEC changed and said we will allow curation. Voluntary disclosure. Remember, the signature move of securities law is mandatory disclosure. But when you're talking about a primary offering, as opposed to a secondary offering, a secondary trading, by which I mean the primary offering is what we're talking about today, when a company seeks investment from investors. And the secondary market is when those investors trade their shares with one another. When investors are trading their shares with one another, the company maybe needs to be told you must provide disclosure every quarter or something, because maybe they won't. But when it's the primary market and there's a company seeking to raise money, the company has a huge economic interest in telling the investors what they want to know. Because if they don't, the investors won't invest. So in the UK and New Zealand, where there's no mandatory disclosure, and they rely entirely on voluntary disclosure, what is disclosed is pretty close to what's disclosed in the US and elsewhere. The silly, wasteful things are not done, but the basics, it's not like the UK platforms and companies just don't say it. They provide tremendous voluntary disclosure. The wisdom of the crowd is the idea that in the aggregate, people know a lot of things. One person knows one thing, one person knows another, and through the market we can bring all that information together. And so the all or nothing model is the key method to harness the wisdom of the crowd. That good companies will reach their targets and bad ones won't, and those who mistakenly pledged towards one of the bad companies will get pulled back from the edge by their fellows and saved. I've told you, in the US this is not working at all because the targets are being set so low that everybody gets funded. I've proposed, and so look, as you can tell by now, I mostly don't like regulations. But there is a time and place, and here's one. There are market failures, and with the all or nothing model in the US, we're suffering a market failure. If one of the leading platforms started demanding that companies announce realistic targets, the entrepreneurs would go down the block and go to one of their competitors where they're sure they're going to get funded. But the SEC can solve this, and my proposal to them is that they should just amend the regulations slightly to say, you can state whatever target you want, but you can only raise up to, say, 4 times whatever the target is that you announce. So you can say 10,000, but that means you can only raise 40,000. And I think that would force companies to come up with realistic targets. And I've suggested also that the US follow, there's a rule in Australia and Canada, I think, that crowdfunding campaigns can only run 90 days, or must run 90 days. So that would solve that problem as well. Let me just mention one more while I'm on a roll, and then hopefully we'll have some time for some questions and answers, at least questions. And syndication is the situation where you have one lead investor. This is what we were talking about earlier with the angels, angels organize themselves into networks, and they say, one of you, Joseph, you go research this company, you're an expert on the situation, on this field, you tell us if we should invest, and then we all will, and they kind of follow the lead investor. And so in investment crowdfunding, a similar thing has been happening in Australia, New Zealand, to a lesser extent the US, but it's starting to become more common, where one large investor, like a venture capital fund, will announce on the platform, the platform will announce, the company will announce, this famous or rich venture capitalist or this angel investor is investing some large amount, $400,000, $3 million, on the same terms that are being offered to you. The crowd then doesn't have to pore over the documents or try to figure out, is this a good valuation? They can just say, well, I'm just going to follow. I think those guys must have done some careful due diligence. They've got a good track record. They're investing a lot. I'm going to follow along, and so that's what I mean by syndication. And this also addresses. There was a thought, particularly, and I still get the question to this day. There was a thought in the early years that investment crowdfunding would have a lemons problem or adverse selection. Meaning, any really high quality company would go get funded by venture capitalists, leaving only the low quality companies on investment crowdfunding, and so kind of, who would ever want to invest in such companies knowing that? Well, like I mentioned a little bit earlier, I guess maybe I won't mention brand ambassadors. Through investment crowdfunding, especially consumer-facing companies can kind of get a double return from their campaign. They can both raise capital for the company, and in doing so, they raise the profile of the company, they grow sales, it's a marketing endeavor as well as a capital raising endeavor. And so increasingly venture capital backed startups, maybe not in their earliest stages, but once they have kind of a fan base, it's in the interest of the company and the venture capitalists behind them to invite the customers to become investors, who then become these brand ambassadors and who always buy that branded beer, or get a subscription to the app for their cousin and retweet, repost whatever it is that the company writes, things like that. So there are good business reasons why companies would use, at least some types of companies, would use investment crowdfunding, and so it's not the case that it's become a market for lemons. There are plenty of companies on there that could have been completely funded by their existing or other venture capitalists and think it's a good business move to engage their customer base. So my basic point is that these are powerful and effective methods, and they allow the market to be reliable and trustworthy and high quality without huge regulatory compliance costs. So I generally, in the book, support the liberal model that calls for essentially just like 3 rules. Require licensed platforms, so you have gatekeepers. Impose an issuer limit so that if anything goes wrong, it won't be too big of a problem. And I think an investor cap is also a good idea to, and I would say do it per investment, because it effectively forces investors to diversify and limits their total exposure. So as promised, here's a promo code on Oxford University Press, ALAUTHC, THC, I don't know why it says it, for ALAUTHC4, you can see 30% on Oxford So thank you very much for your attention and the opportunity to speak, and I look forward to your